Yes.
Mr. Fish, I'm going to ask you about some of the kinds of reasons applications would not succeed next. And I'm going to ask you first about the approach taken to applications based upon receipt of anti-D immunoglobulin. So if we could, Seamus, have SKIP 5031 _ 071. This is a letter written to your predecessor, to Mr. Foster, February 2005. So I think you'd have been employed by the Skipton Fund for only 2 or 3 months at this stage. It's from Dr. Patricia Hewitt, the National Blood Service, and it sets out various matters relating to anti-D immunoglobulin. Now, I'm not going to go through the detail of the report. We've seen a further report obtained from her in 2010. But can you assist us with this? What was your understanding of the report, and to what extent did you rely upon it when you were considering applications?
So it was my understanding that anti-D, as used when I think there's a difference in a particular part of the blood group of mother and baby, it was quite commonly given during pregnancy and childbirth. And this report that we were provided with confirmed, in our view, that it was not a possible source of hepatitis C. Unless it was a specific exceptional circumstance where it was a different type of product that was given intravenously. Now,
if you had an application from someone whose application was based upon receipt of anti-D immunoglobulin, did the application essentially automatically get refused, or were steps taken to investigate the individual circumstances of the applicant and what product she had specifically received?
So yeah, normally it would be something mentioned in the medical records, and from that it would be seen whether or not it was one of those exceptional circumstances or if it was a sort of routine anti-D injection. If there wasn't information to that effect, we would obviously ask for the records that mention the anti-D.
Was it, as far as you can recall, usually possible to determine on the basis of typical medical records which anti-D product an individual had received?
Yeah, as far as I recall. It would have been obvious if there was something unusual about when it's mentioned, anti-D. I believe that was only used incredibly rarely on a named patient basis, but for quite a different purpose.
Do you recall ever approving an application where the route of transmission was said to be receipt of anti-D immunoglobulin?
No, not as far as I recall. We didn't have all that many anti-D applications, but I don't recall approving one.
If an applicant had received gamma globulin rather than anti-D immunoglobulin, was there any particular policy or approach in assessing the risk of hepatitis transmission in relation to such a product that you can recall?
That's quite technical, so at the time I would have known more about the differences or similarities, but unfortunately, no, I can't recall. No.
Was a copy of Dr. Hewitt's letter provided usually to applicants whose applications were being rejected so that they could understand the basis for that and if they wanted to challenge it?
No, I think our letter said that we'd been informed by the National Blood Service that anti-D wasn't a risk factor for hepatitis C, but I don't think, as a matter of course, we provided a copy of that letter.
Do you think it might have been a good idea to do so, at least in the interest of transparency, so that the individual could understand the reasons why their application had not succeeded?
Possibly. It's quite a technical letter. It's quite difficult to understand some of it, but I mean, if someone requested further information, we happily would have provided it. But yeah, I guess we would have had to have sought the permission of Dr. Hewitt as well. So yeah, we could have paraphrased, but I'm not sure we could have just shared that letter. But yeah, we could and did provide further information on request.
Dr. Hewitt was, I think, appointed to the appeal panel in October 2006. Is that right?
Yes, she was one of the original members.
Maybe this may be more a question for Professor Mildred, or indeed in due course Dr. Hewitt, but were you ever concerned that effectively she'd be assessing the value of her own expert opinion if she was considering appeals in anti-D immunoglobulin cases?
I think maybe the panel shared that view and they sought literature review from bioproducts laboratories, so they got an independent person to provide their view as well. I'm not sure if that was because of the conflict that you mentioned, but that is something that they did.
Well, we can take that up perhaps with Professor Mildred later this week. Intravenous drug use. Now, if we go then to SKIP 5031_221. So that's your letter. This is a letter, I think, written by you to Dr. Ramsey Health Protection Agency, asking for a opinion about use of IV drugs as an alternative cause of infection to blood transfusion. Do we correctly understand from this that this was something the appeal panel was seeking rather than something you and the directors had decided to obtain yourselves?
Yes, that's right.
And if we then go to the report, which is SKIP 5031_217, this is the report that you received. If we go to the conclusions, perhaps on page 4. We can see in the summary, Dr. Ramsey says, overall, the risk of hepatitis C infection with short-term injecting in the UK is poorly documented, is likely to have varied geographically and over time. Although data on one-off or casual injectors is absent, evidence from many countries supports the belief that the risk of acquiring hepatitis C in the early period of injecting is high. The estimated probability of transmission from single episodes of needle and syringe sharing also appears to be substantially higher than the risks associated with a single transfusion of unscreened blood. On an individual basis, it will be difficult to assess the risks associated with single episodes of injecting where sharing is denied. But recent studies suggest that the incidence of hepatitis C in injectors who deny sharing is around half of that observed in those that do report such behaviour. What was your understanding of the significance of Dr. Ramsey's report for your decision-making processes?
I believe it backs up what I'd been taught when I first started with the Skipton Fund, that the risk from intravenous drug use were far higher than from a one-off transfusion. Obviously, different blood products, for instance, I mentioned clotting factor earlier, we know that that's 100% chance of that being infected with hepatitis C. So if someone had received clotting factor and had a history of intravenous drug use, they still would have been approved. But for one-off transfusions, we believe this just backs up our view that it was much more likely that the intravenous drug use would have been the source of infection.
And you said in your witness statement, I don't think we need to put it on screen, it's your second statement, I think, you said that during your training period, you were told that for any application where there was a history of intravenous drug use, this would be considered a more probable transmission route for hepatitis C infection than treatment with an NHS blood transfusion. So is this like that was the guidance or instruction you were given at an early stage of your employment with the Skipton Fund?
Yeah, for one-off transfusions.
May I just ask you this? The risk of transmission of hepatitis C comes with the risk of blood being transferred, does it not?
Yes, blood to blood.
So if a needle is the source of the entry of the blood into the body, it has first to be used on someone else.
Yes, but not just a needle, the
So-
paraphernalia, so the spoons and the associated equipment can have traces of the blood as well. I believe that's documented.
I see. So the source may be from blood, which is on a spoon, heating the
Potentially, yeah.
heating the drug.
Yeah, so it would have had to have been blood from someone who had hepatitis C. But yeah, it could have been on the needle or any of the associated equipment. But
So-
obviously, if everything was sterile and clean, then there'd be no risk.
So if someone says honestly in their application form, yes, I have used intravenous drugs on one occasion. I had a fresh needle. That would be more likely to give them hepatitis than an injection, would it?
Yeah, it's obviously difficult to assess, but I'm not sure if people who inject intravenous drugs for the first time would do so on their own with sterile equipment. But if there was somehow proof that that was the case, then it can be considered a risk factor.
Yes, so quite a lot of assumptions involved in this conclusion. Would you agree?
I don't recall anyone or any doctor saying the person's used intravenous drugs on one occasion on their own with clean equipment and brand new equipment. So I don't think we ever actually assessed such an application.
No, the reason I ask is that yesterday I was reading a statement from someone who remains anonymous, who said, I used drugs once. I used it on my own, and I used a fresh needle. I was rejected by Skipton. That's what they said. Now, that's why I'm asking you these questions.
Yeah, I don't recall an application where that was something we had to decide upon.
Thank you.
To what extent, when deciding applications, did you place reliance upon Dr. Ramsey's report?
So it did back up what we had as our view already. So I wouldn't say we relied upon it because we'd already been making decisions on the same basis. But yeah, it was certainly something we could refer to and could make available to applicants or appellants on request.
If we just go to SKIP 5048_332. This is an email from Professor Mildred to you, 2nd of April 2007. We just look at the second paragraph. Will the fund now use the Ramsey report when dealing with applications involving intravenous drug use? The panel thinks it is important for consistency that it should. Can you recall whether, in light of this email setting out the panel's view, it became your practice to expressly rely upon the Ramsey report in decision letters?
Yeah, we certainly changed our wording of the decision letters. I think it said the Skipton Fund has an expert report setting out the risk factors. So yeah, we did amend our letters accordingly.
And is this right that you didn't provide a copy of the expert report at least not unless it was expressly requested by the applicant.
Yeah, I don't think we sent that out with every. I mean, there weren't all that many IV drug use applications, but I don't think we sent it out. But we certainly did send it on request. It wasn't classified or secret report. We could share it and did share it.
Dr. We can take that down, thanks. Dr. Ramsey's report, I don't think we need to go back to it, but she talks about risk being poorly documented. She talks about geographical variations in relation to risks, and says it's difficult to assess risks associated with single episodes of injecting where sharing is denied. Did you understand Dr. Ramsey's report as excluding IVDU, intravenous drug use, excluding transfusion in any case of intravenous drug use? Or did you understand it to be more nuanced and requiring individual assessment?
I think in that paragraph you showed me, it did say that even if there was a denial of sharing needles or equipment, there was still half the risk of people who admitted to sharing the equipment, which would still be a much greater risk than a one-off transfusion. So, yeah, in my view, it did exclude even a single episode of intravenous drug use.
And presumably that incidence of hepatitis C in injectors who deny sharing is explained by that being an inaccurate denial of sharing, because if a person had not, as a matter of fact, shared, they couldn't contract hepatitis C from drug use, could they?
I mentioned about the paraphernalia, so it could well be that what they said, this was part of the study, not something we did, obviously. But yeah, perhaps they honestly said that they didn't share needles, not knowing that there was a risk associated with sharing other equipment.
Did you ever consider the significance of the dates of transfusion compared with dates at which the intravenous drug use took place, to ascertain if a person had been transfused?
Yeah, certainly something we did look out for that.
And did that make any difference to the success or otherwise of applications?
Would have done if there was a positive Hep C result before the incident of sharing needles or IV drug use. So I can't remember every specific claim, but that may have happened in one or two.
In the absence of a case of the kind you just described, so where there's a positive hepatitis C result before any evidence of intravenous drug use, did you ever, as far as you can recall, approve an application in which there was evidence of intravenous drug use?
Not that I recall. I don't think so.
Would it be right to say that, very much as reflected in what you've told us your training was, that there was in effect a blanket policy to regard intravenous drug use as the more likely cause in all cases?
Yeah, unless the person had a look-back letter or had received factor concentrate, where we know that was the source. Not just factor 8, any factor.
If an application was received from someone who had they said, some very limited exposure to intravenous drugs, but had repeated transfusions, so leave aside factor concentrates, because you told us what the position would be in relation to that, would the policy still have been to reject the application without further investigation?
No, we would have tried to find out more information if that was the case. But extent of the transfusions, for instance.
But you can't recall, and I appreciate you won't necessarily recall all individual cases, Mr. Fisher. I don't want this to be an unfair question at all, but you can't recall allowing any applications in which there was intravenous drug use as a potential contributing cause?
No, I guess because IV drug use was quite rare, as were conditions requiring multiple blood transfusions, so I don't remember the two coinciding.
When the case of someone whose application was being rejected on the basis of intravenous drug use, when you wrote to them to tell them the position, were they given the same information about the possibility of making an appeal, or were they told that an appeal was also likely to be unsuccessful because the panel would place the same reliance upon the Ramsey report as the fund did?
Yeah, we didn't tell them the likelihood of success, but we certainly informed them that they had the right to appeal.
So what was the approach, if this ever arose, in relation to non-intravenous drug use, for example, intranasal routes of administration of drugs?
Yeah, it's a bit more difficult, so there wasn't as good information about the prevalence of hepatitis C amongst cocaine use, but there is, for instance, even on the Hep C Trust website, you can see that it does say that sharing straws when snorting cocaine, because of the delicate blood vessels in the nose, there is a chance, if you're sharing a straw with someone who's got hepatitis C, there is a chance of infection through that route.
And did you have such cases which were rejected for those reasons?
I think I can recall one that was rejected. There may have been more, but I do remember one, certainly.
Did you have any understanding as to whether this approach to IV drug use is, and the policy that you've described being taught in your training period, did you have any understanding as to whether that was dictated or determined by the Department of Health, or was that the Skipton's own assessment of the evidence?
Not sure, but some of the documents you made available about when they were discussing the application process, I think it was mentioned there, wasn't it? So I think it's something that the Department of Health no doubt had an opinion or guidance on.
I'm going to move to ask you next about another cohort of cases, natural clearers, if I can call them that. Were you ever involved in any discussions about the exclusion of natural clearers from the scheme?
No, that was something established by the time I started.
Was the test for determining whether someone had cleared hepatitis C in a 6-month acute stage determined on the balance of probabilities?
Yeah, so we relied on the doctor to say whether or not they had evidence of chronic infection. So yeah, it was still a balance of probabilities applied to that.
How straightforward or easy was it to consider the applications from people who might fall into that category and make a decision?
So the majority of applications would have just said, the doctor said there's no evidence that they're PCR positive, but there is evidence of antibodies. And then the next question was, is there any evidence of chronic infection before naturally clearing it? So they would have said yes or no to that. So the majority of cases would have just been a straightforward section, I think it was 2, would have just said yes, they have had antibodies, which shows previous exposure, and then no to the next 3 questions. So yeah, those are straightforward to consider.
Mr. Stevens, in his witness statement to the inquiry, referred to the approach of Elizabeth Boyd and suggested her approach was not to approve stage 1 applications for people who were shown as having been hepatitis C positive after the acute phase, but not currently hepatitis C positive as shown by a PCR test, because that was the approach that the Royal Free, where she worked, took to deciding whether to validate applications or not. Do you have any recollection of Ms. Boyd's approach in that regard?
No, I don't. I mean, a lot of these, because I think my predecessor had to one side the applications where the answer was yes to antibodies, no to PCR positive, and then yes to evidence of chronic infection beyond the acute phase. So they were all put to one side. I think there was back and forth discussions with the Department of Health, and then like a lot of those in bulk were dealt with while I was still the scheme assistant. But no, I didn't remember Elizabeth dealing with them particularly differently.
Okay. Could we next go to NHBT 0090,734_001. So this is in relation to cases where third-party infection, sexual transmission cases. And it's a note from you dated November 2006, and you say, I've reviewed all of the sexual transmission third-party infection cases that I was able to locate from our files, and it would seem that we began requesting genotypes from both parties as a matter of course in early 2006. The reason for this has been covered in one of the emails from the chairman included in the case papers. The directors of Skipton have a job to do, which includes the proper management of a scheme that was not fully defined when it was started up. The requirement for genotyping applies to a tiny number of cases and is a detail that those drawing up the scheme and its operating procedures did not and probably could not have been expected to foresee. Before this time, I found a couple of cases where the genotypes were included on the application form, but the doctor had provided the information without us requesting it. In most other early cases, it would seem that no request for genotypes was made. First question, Mr. Fish, is the passage set out in italics from the chair refers to the proper management of a scheme that was not fully defined when it was started up. Do you understand what he meant by that?
Yeah, I think he meant that things such as genotypes to help back up a third-party claim hadn't been considered or thought of. You must be referring to that sort of oversight.
And why was it had you been asked by the chair or the directors to review all sexual transmission third-party infection cases, and if so, why?
Yeah, so I think it was Elizabeth who wanted us to ask for genotypes to just help back up the third-party claims. So yeah, it must have been something that the board asked me to review.
Could we next go to NHBT 0091224_007? So these are some email communications between you and, first of all, Dr. Hewitt and Professor Mildred, and then to Mr. Stevens and Ms. Boyd. So if we pick it up on the third page, and bottom half of the page. So actually, I think we should go to the fourth page to put it in context. So there's an email from Mark's, that's Mark Mildred, to you, August 2011, asking this question. The haemophilia cases have made us think again about the scheme. Is the proper criterion simply treatment with blood or blood products in NHS clinics? Or must that treatment also be with NHS blood or blood products? And then there's a specific question about cases involving haemophilia. If we then go to your response, so we go to the third page. Bottom of the page. Thank you. So this is your response. You say the criterion is that a payment can be made to somebody who before September 1991 was treated with NHS blood products or tissue, etc., etc. And then you say, so the treatment needn't have been in an NHS clinic, but the blood products must have been from the NHS. And then if we go up the page, Professor Mildred says in response, and this, we needed clarity on the question whether the concentrate had to be NHS made as well as delivered. And then if we go to the second page, before I ask a question, bottom half of the page is an email from Dr. Hewitt to you and to Professor Mildred. We can agree that anyone treated with clotting factor concentrates, whether NHS or commercial, would have a close to 100% probability of hepatitis C infection. The majority would have had chronic infection, etc., etc. it would appear from this that as late as August 2011, which is a number of years after the scheme had been set up and been operating, that there seemed to be some doubt, at least in the chair of the appeal panel's mind, as to whether the scheme was limited to products made by the NHS or not. Can you assist us with why, which would have excluded then those infected through the use of commercially produced concentrates? Can you assist us with how this issue came to arise in 2011?
It may have been that obviously we considered thousands of applications, they only considered a few hundred, so perhaps an occurrence hadn't, because they didn't actually consider many haemophilia applications, if any, because most of them are approved by the Skipton Fund itself, so maybe it wasn't an issue that had cropped up for the appeal panel before. But from our point of view, if commercial factor was purchased by the NHS, that becomes an NHS product. It didn't have to be manufactured by the NHS.
Well, maybe we can pick that up again with Professor Mildred, but if we go to the first...
There's also, I think, an ambiguity in the phrase which Mr. Fish quoted. NHS blood, that's obviously NHS blood, blood products, etc. So the question is whether the NHS also qualifies with blood products.
Yeah, so any products...
It's one of these linguistic, grammatical questions. It's ambiguous on that basis.
Yeah. So, yeah, any blood or blood products that were administered by the NHS, we would have considered as qualifying.
Well, that's a different question. But if the question of whether NHS, meaning NHS origin or NHS production, that's one thing. NHS administered, that's another. But NHS blood, blood products, that could mean, I don't think it's likely, but it could mean blood products which are not NHS.
Yeah, could be, but I'm not sure what they would...
Anyway, I think rather esoteric dispute.
Yes, it just seemed rather curious that it had arisen in 2011. Can I just ask if you look at the first page and just assist with what you meant in your email then to Mr. Stevens and Ms. Boyd. You refer to the email exchange and then you say in the second paragraph, if we are all in agreement, it would seem that we can start to approve applications where an individual was known to have been treated with clotting factor concentrates before screening began, and where there are no records which suggest that they might have been one of the minority who naturally cleared HCV without experiencing a period of chronic infection. Can you assist us with what you mean there by starting to approve applications? Because, again,
Yeah, sorry, I think this is referring to people who died before 29th of August 2003 who were originally excluded from the scheme. So I was essentially saying that they were put to one side until this was clarified, because I think this was in 2011 when the changes occurred to the scheme. We were saying that if there was, the Haemophilia Centre had them on their database as someone who'd received clotting factor, we are saying that they would have been exposed to hepatitis C, even if we didn't have explicit records showing that they received a particular batch. They were on that database, we know that they would have done. So it helped us to assess those claims where the person died so long ago, there were just no records available.
Thank you. That may assist in understanding why the issue was arising then. Thank you.
Yeah, it was about those pre-03 cases, I think.
And then just the next category of cases I wanted to ask you about is just cases that turned on the September 1991 cut-off date. Was this your understanding that as far as the Skipton Fund was concerned, there was no flexibility to that date because the agency agreement essentially pinned eligibility to pre-September 1991 infection?
Yeah, that was the health date that we had to use with no flexibility.
And then if we could go to SKIP 5030_009. So these are the minutes of a meeting of the Board of Directors, February 2014. If we go to page 4, please. If you look at the paragraph that bears the number 168 next to it, so it's towards the top of the page, exclusion of applicants who've already been compensated for their HCV infection through the NHS. The scheme administrator reported that the DH had indicated in a recent telephone call that it was their intention to exclude people from the scheme who'd already received compensation for their hepatitis C infection through litigation. At the moment, it was unclear if this would be limited to future applicants being asked to confirm that they'd not already been compensated, or include existing applicants who were receiving regular payments. And then it refers to you having submitted some draft wording on the application form and guidance notes to the Department of Health, and Department of Health lawyers now considering it. Can you recall how that issue was resolved, Mr. Fish?
Yeah, we certainly didn't look at applications and ask if they'd received compensation, so it must have been dropped by the Department of Health. I don't ever remember them asking us to check if someone had been compensated.
Now, going to come back now to the question of medical records and the approach when there were no medical records. If I can start by taking you to DHSC 30/4510_045. This is a letter from you dated the 26th of January 2006 to somebody in the blood policy group at the Department of Health. And if we go to the third paragraph, we can see it says, as the scheme guidelines set out by the Department of Health currently stand, it is necessary for the clinicians completing application forms to have seen medical records which confirm blood or blood products were administered to their patient through the NHS prior to September 1991. As you are aware, this is unfortunately not the case with Mr. X's application, and the fund therefore had no choice but to decline his application. Now, this would suggest it was your understanding, at least in January 2006, that the existence of confirmatory medical records, at that point seen by the clinician rather than sent to you, but the existence of them was a necessary prerequisite, with the fund having no choice but to decline the application in the absence of such records. Is that correct? Was that your understanding at the time?
Yeah.
Did that change?
Only I think that we didn't need the records to explicitly mention a blood transfusion. If there was good evidence that a blood transfusion would have been probable, then we could still assess those. So I'm not sure if that's a difference, I guess. Yeah. I guess that is a slight difference.
If we go to ARCH 302318, so this is the written material submitted to the Archer inquiry on behalf of the Board of Directors of the Skipton Fund by Mr. Stevens and Mr. Harvey. If we go to the third page, we can see bottom of the page, section 8, level of evidence necessary to qualify for payment. SFL, so that's Skipton Fund Limited, considers applications on the balance of probabilities where, firstly, there is evidence of an applicant receiving blood or blood products through the NHS prior to September 1991, but not necessarily identifying a batch of blood that was infected with HCV. And secondly, there is an absence of other significant risk factors. Now, that would appear to suggest that if there were other other significant risk factors, that would be essentially exclude the application from succeeding. Is that correct?
Yeah, if it was a significant risk factor or significant enough that that was felt to have been the probable source of the infection.
And then Mr. Stevens and Mr. Harvey come on to the question of records. In cases where there are no medical records which confirm the applicant was treated with blood or blood products, the directors of SFL exercise discretion where appropriate. And then we've got the 3 examples that we saw in that footnote I think your annual report, Mr. Fish. So, where a transfusion would definitely have been needed, or where there's a disease for which treatment would have involved the use of blood products. And then there's the example given of the elderly applicant and the clinician with no doubts of the source of infection and a strong letter of support. And then it says this at paragraph 8.3, if there are no records available and the treatment with blood products is simply in the applicant's memory, then the application must be declined and referred to the appeal panel if the applicant so wishes. Is that an accurate reflection of the approach which the fund took to applications where there were no medical records?
Yeah, I think you mentioned that there was nowhere on the form for people to give their personal accounts. So that was a design at the outset of the scheme. So no, we weren't able to make applications where someone had hepatitis C and they recall having a blood transfusion, but that's the extent of the evidence. That's not something we were told we could approve.
Want to look with you at a document that I think you almost certainly wouldn't have seen at the time you worked at the Skipton Fund, but which has, I hope, been sent to you in advance of your evidence. It's DHSC 001 4979 _004. Now you'll see from this, Mr. Fish, this is headed HIV Blood and Tissue Transfer Scheme, and it's a determination of the panel in two particular cases. And it's the inquirer's current understanding that this is effectively in relation to the scheme for those who were infected with HIV through blood or tissue, and who would then, if they're accepted as eligible, would then be able to receive financial support from the Eileen Trust. And if we go to the next page, and I want to ask you about the general approach which was taken and whether it was ever considered by the Skipton Fund. So various matters are set out in terms of an appellant diagnosed as HIV positive and his deceased wife who'd also died of the AIDS virus. And we can see both claims, this is the first paragraph, having been rejected on the ground that blood transfusions given to the deceased were not the cause of the infection. We go to this next page, please.
Sorry, who was that rejected by? Do you know? By the Department of Health?
It may have been rejected by the Department of Health and then effectively allowed by the panel. I think that's right. And then we can see paragraph 4 says that there's a suggestion of a transfusion of fresh frozen plasma, no record in the hospital notes of any such transfusion. And then we can see the determination sets out as follows. There are, it seems to us, only 4 possibilities, and the 4 possible routes of transmission are set out. Paragraph 6 then says, on the face of it, none of these 4 possibilities is a likely one. Indeed, on the available evidence, each is unlikely. We must therefore consider the evidence and conclude which of the 4 is the least unlikely. And then that's precisely what the determination then does. And the conclusion, if we go to page 7, Shomik. Paragraph 21 is, balancing the unlikelihoods, we've therefore concluded that the least unlikely by some margin is an unrecorded transfusion of infected plasma in 1984. And I'm not inviting you to comment, obviously, on the individual case about which you'd have had no direct knowledge at all, Mr. Fish, but was this kind of approach ever either suggested by the Department of Health to you or contemplated by you or the directors? Were there a range of possible causes, examination of which was the least unlikely?
No, that was never suggested to me.
We can take that down, thank you. We've heard, again, just sticking briefly with the Eileen Trust, some evidence that there was a caseworker at the Eileen Trust who was able to assist applicants with tracking down medical records. Did the Skipton Fund ever offer such assistance to applicants?
We offered advice of who they should approach and how to request the records, but I'm not sure we had that level of. So, what was the caseworker who would meet them, or yeah? Because I think the Island Trust at its maximum had 100 beneficiaries. Obviously, the Skipton Fund, we dealt with thousands of applications, so that might be why the Department of Health set it up slightly differently.
So,
or very different.
Sorry. So the Skipton Fund would not itself take steps to obtain records. It would expect either the applicant or the clinician completing the form to provide them.
Yeah, and I think we may have written to a hospital to request records, and we would have got a response saying that they need the applicant to request them in person, not in person, personally. I think we had the authority to request people's records.
What was the Skipton Fund's approach to the costs implications for applicants, many of whom may have been living in poverty, in trying to obtain copies of their medical records?
So occasionally we'd hear of or receive an invoice from a GP, or it was almost always a GP. I don't think specialist doctors in hospitals ever sent such letters, but they would say there's a fee for the completion of a form or for the records. So the Department of Health's instructions that we couldn't cover those, but we did write back a letter explaining that this is nothing like an insurance request form, and such fees should not be levied by the GPs or the hospitals. Whether or not they listen to our advice, I'm not sure, but that's certainly what we told them. They shouldn't be charging applicants.
Can you recall if you ever approved an application in, leaving aside bleeding disorder cases, whether you ever approved an application in the absence of medical records confirming a transfusion?
Yeah, certainly once it didn't confirm a definite transfusion. But yeah, I don't think we approved anywhere there was literally no medical records at all. But yeah, there could have been, or there certainly were ones where there were records that described treatments and injuries but didn't specifically mention blood. We were aware that discharge summaries didn't always routinely refer to blood transfusions. But we did approve applications where it didn't explicitly mention the blood transfusion.
I know you've seen the report prepared by the inquiry, Mr. Fish, which includes reference to the numbers of cases declined on the basis of lack of medical records or lack of other evidence, and also gives some case summaries. I'm not going to go to the details of any of them, but a theme which seems to emerge from that is that it was fairly common for applications to be rejected because of an absence of medical records. Are you able to assist us in understanding more about that?
Yeah, it's probably about a quarter of applications, about a half were natural clearers. In fact, I've noticed in your numbers, I think you might be missing 3 lever arch folders worth of natural clearer rejections. The solicitor should have those if you request them, but they were stored in lever arch folders instead of box files. So that was half of the declines were natural clearers, then about a half again, or maybe slightly more than half, were a lack of evidence of a probable transfusion, and then the other quarter would have been other reasons, IV drug use, anti-D, etc.
If we have a look at your witness statement, so if we go back to WITN 4466002, please. And we go to page 14. So we can see there you were asked questions about the extent to which the Skipton Fund sought medical advice, and you refer in the bottom of the page to Elizabeth Boyd. I've asked you about that. You've referred to Professor Mutimer, and I'll come back to that when I ask you a handful of questions about stage 2. payments. But if we go to the top of the next page, you then refer to the appointment of Professor Thomas, and picking it up about halfway down that paragraph, you say this: rather than reject an application where the medical records didn't explicitly mention the use of blood or blood products, it was felt that it would be fairer that a medical director within the fund consider what medical evidence was available so that they could make an informed judgment of whether they believed treatment with blood or blood products was probable, i.e. more likely than not, and the application could proceed as such. And then you refer to it being beneficial for Professor Thomas to have another medical director to discuss such cases with us. They were not always straightforward. Is it an accurate inference from what you've set out in that paragraph that prior to Professor Thomas's appointment in late 2012, early 2013, there were a number of applications rejected by the Skipton Fund because they were not straightforward cases, there weren't medical records, and there was a dearth of medical expertise to accommodate this?
Yes, although they would presumably have been considered by a doctor via Elizabeth Boyd. Obviously, I don't have access to the files now, so I can't say that's what happened in every case, but it was essentially saying that it was better to bring in the expertise in-house.
Now, Professor Thomas's area of expertise was hepatology, and Professor DeShaco, who was then appointed a little later, likewise. The transfusions that many Skipton Fund applicants would have received would not have been administered by hepatologists, but would have arisen in the context of surgery, sometimes cancer treatment, childbirth, and other medical interventions, including emergency medical interventions. Did the fund ever consider having a panel of clinicians with a broader range of expertise that you could go to say, well, in the course of orthopaedic surgery or ear, nose and throat surgery for this condition, is it plausible that a blood transfusion might have been given?
Yeah, I'm not sure to what extent that was considered, but obviously their expertise does go beyond just hepatology. And I think on occasion they did seek the opinion from colleagues who are experts in other fields. But in terms of whether or not we ever considered getting any more medical directors in-house, I'm not sure we ever formally made that.
Can I come on then to ask you a handful of questions? Oh, no, I note the time. I was going to move to stage 2, but it's almost 1 o'clock. It might make more sense to do that after lunch, sir.
Okay, we'll take a break now then until 2 o'clock. The same rules apply that I mentioned this morning about talking to others about what you've been saying or what you think you might yet have to say. But look forward to seeing you back at 2 o'clock.
Thank you.